I'm Maurice Crespi, Managing Partner of Schindler's Attorneys. We're joined today by Ian Fleming of Engaged Business Turnaround, Dean Wright, who's my partner at Schindler's as well, and Francois, who is from the IQ Business Group. There may be other panelists who will be joining us. Well, here we go. We've got Peter Gordon, who is also from Engaged Business Turnaround. So the idea for today is to encourage and try and get you guys to ask questions, and we deal with them and we debate them and we answer them specific to the situation you find yourselves in. The reason I say that is this is a webinar, and it'll be quite easy for us to simply record a video and play the video at 10 o'clock every day. So I'd ask that you do pose some questions, whatever they may be. You can do so anonymously, and let us tackle them. Let us deal with them. Before I kick off, we're going to be dealing with business rescue, but I think it's important for us to, for the audience to understand that COBRA is not about business rescue. COBRA is about avoiding a business rescue. So the first phase in COBRA is to try and convince creditors and creditors to come to the party and to be reasonable and to not start suing, because there's no point in sucking blood from stone. Once the creditors are contacted, COBRA will encourage them to come into the ecosystem, and then we'll in turn deal with their creditors, and it goes all the way up to the bank. If we're able to achieve that, there's no reason to go into business rescue. You'll hear about the moratorium on business rescue, which is very, very important, a moratorium on being able to claim. And that moratorium will then level the playing field if you do have a creditor who's being unreasonable. So we'll discuss business rescue today, but please understand that COBRA wants to avoid a business rescue. So the first port of call when it comes to COBRA is to get onto the phone with your creditors and have our mediators intervene to try and negotiate an arrangement. The mediator's job is to bring impartiality to the discussion and to give each party comfort that they're not being duped by the other party. So just be mindful of that. So I'll kick off with Peter. Peter, if you just give us a general outline of what business rescue is, and what it's about and why we have it. There's an article, incidentally, before we get to you, it was published, and I don't have it in front of me, but in the article it basically said that business rescue is not successful, was the one point that it made, and the second point was that business rescue is turning out to be nothing more than adding to the costs of an inevitable liquidation. Peter?
Mauricio, thank you for that, and good morning, everybody. Very briefly, business rescue, it falls under Chapter 6 of the Companies Act. It's broadly the same as Chapter 11 in the US, or administration across most of the Northern Hemisphere and Australasia. It's designed to avoid liquidation. It's designed to help a company survive, obviously through a boost to the economy if it does survive, and most importantly in the South African context, to secure jobs in a country where unemployment is so high. The principles of business rescue, it's obviously is a legal process driven by the Companies Act. And what it allows the company to do is it creates a steel blanket around the company for any legal action against the company. And that's not any legal action for the recovery of debts that the company might owe its creditors, but any legal action cannot be taken against the company. That includes SARS, SIPC, any regulatory authority, etc. So it's the moratorium that Maurice refers to is absolute. What it entails is normally a board resolution, fairly straightforward. The board has to vote on it. They agree by a majority of 50% plus one to go into rescue. The board then is obligated to appoint a practitioner. The board's resolution, together with an affidavit, and the affidavit signed by the director is quite important, because what that states is in summary the reason for why the company is financially distressed, but most importantly that the board believes that given time of protection, the company will be able to trade out of its current position. The company then has to appoint a business rescue practitioner or practitioners. You can appoint as many practitioners as are required. So obviously for the larger companies, you often find 2 or 3 practitioners. Those resolutions are filed at Companies House with a couple of SIPC forms, and the company is immediately thereafter in rescue. We talk about drawing a line in the sand. Anything that is owed on that date gets frozen, and anything that happens after that date is then given preference. So anybody providing facilities, whether that's goods, services, time, your employees providing time to the company are creditors each day that they remain unpaid, are then preferred over any other creditors that were in existence, including secured creditors, prior to the rescue date. The negative response to rescue, it is accurate. Rescue hasn't been that successful in many cases, and that's on a number of factors. Firstly, a lot of companies believe that this protection is the way to defer a inevitable liquidation. In the early days, and I've no doubt will still happen, mainly the banks were applying to the courts to have rescues overturned on the basis that they thought there was no hope in hell of the company being rescued. Predominantly property type developments where the bank saw some value in their security, normally a mortgage over their freehold, and the bank was anxious to exercise their security, which of course they can't do whilst the company's in rescue. So a lot of those initial rescues were overturned by the courts and turned into liquidation, and obviously those features as negatives in the statistics. But there's also that thing of pie in the sky, entrepreneurial businesses that believe everything's going to be great tomorrow. Remember, a rescue practitioner's got to be independent, so he probably hasn't had too much time to examine the affairs of the company. In fact, he's got 3 days if he's new to the company to decide whether to take it on. We do like, Ian and myself, to try and get involved in the early stages prior to rescue to try and get a flavor of whether the company can be rescued. But an important point here vis-a-vis liquidation is if the practitioner is appointed and then decides that the company cannot be saved in a rescue, he or she is obligated to put it into liquidation. So there have been a number of those, probably not enough. I think there are rescue practitioners that decide just to hang on to the rescue to see if they can earn an annuity income out of it. That's a bit cynical statement, but it is reality. And I think there are, the reputable practitioners will not, if they've believed in the first 3 days that the thing can be rescued, and then find that, you know, what they've been told is inaccurate, then they do put the company into liquidation straight thereafter. So yes, there is some negativity, but, you know, hopefully, and that negativity is not helped with things like SAA, which was a positive when the government put it into rescue for the rescue industry. But of course, with the government now stating that they're not prepared to fund the post-commencement finance, which I'm sure we'll talk about later, you know, that's going to be a huge negative on because SAA, the practitioners will then be obligated to put SAA into liquidation. They don't have a choice to do otherwise. Maurice, I don't know whether that covers it for you. That's
great. Brilliant. I think let's just jump into a practical example as to what you guys will actually do. Yeah. Hypothetically, let's say a bakery business comes to you, they're distressed. In February this year, they were doing really well. Their profits were in the region of around 20%. They've come to you now and they're 10% underwater. What do you guys do? So you've now just received the phone call, Ian. What's the next step?
Maurice, the first thing to do is okay, so we have a phone call with the directors, with all the principals of the business. We ask them a lot of questions. We ask them what they believe the causes of distress are. We basically build a picture in our heads as to how big the business is, what the turnover is. We get an understanding of the financials of the operations, how many people they employ, for instance. And then once we've built that picture, then we ask them for the financials. In other words, the latest financial information that they have, management accounts and so on. We get our heads around that, and we start building an idea in our heads as to whether the company is rescuable. Look, under COVID-19, everybody's faced with the same crisis, and the reasonable prospects of rescue is normally there. Once COVID-19 is over, start rebuilding, and hopefully everything gets back to normal eventually. So to have whether there's a prospect of rescue under COVID, most likely there is. But the first thing for us to define is what the problem is, what the biggest problem is that has caused them to go into financial distress. Once we've realized what that problem is and we've discussed it with the directors and so on, then it's up to us to work out whether that problem can be fixed and what the likelihood is of fixing it, and what's the amount of resources and so on that we need to apply to it, whether it's feasible to rescue it at the end of the day. We need to consider the financial resources that need to be applied to it, the post-commencement finance, the investment in human capital, and so on. Sometimes we realize that the company is just too far beyond saving. And then, as Peter said, it's our duty to either liquidate it. If the creditors cannot get a better return than in liquidation under business rescue, then it's our obligation to liquidate it once we've been appointed as a business rescue practitioner. Otherwise, there are various options that we can consider. Consider doing an informal turnaround, in other words, a turnaround outside of business rescue. We can consider whether a compromise in terms of the Companies Act, in terms of Chapter 6, Section 155 might be appropriate, and we can consider whether to put it into business rescue.
Let's deal with 155 for the audience, sorry.
Section 155 is a compromise arrangement that can be entered into with creditors, as opposed to putting the company into business rescue. So in a compromise situation, you don't put the company into rescue. In other words, you don't get that steel blanket, as Peter calls it, of protection around the company from the word go. What you would do with a Section 155 is typically where you've got a friendly set of creditors, so there's no creditors bashing the door down to liquidate the company. You would then put together a plan, a compromise plan, that shows how the creditors will each take a haircut. In other words, how they will each be compromised. And in each class of creditors, how each class of creditors will be compromised. Then you'll put it out to a vote by the creditors, and each class of creditors has to vote in favor of the plan, in favor of the compromise plan. And once you pass a 75% vote in each class, then you get it made an order of court. And then the creditors each take a haircut, and the company can continue with its operations. The main disadvantage is that it doesn't have the protection of business rescue right from the start.
But you can always start with that and try a compromise. If that doesn't work, then go to business rescue. I think we'll be seeing quite a few of those compromises, because there's no money. If there's no money in the system, there's no option but to compromise.
Well, so, absolutely. And we obviously, under business rescue, we obviously compromise a lot. The business rescue plan normally entails a write-off to some extent of the creditor's debt, especially if the company is factually insolvent by the time it comes into business rescue. So 95% of the time there is some sort of compromise envisaged, be it under a Section 155 or be it under business rescue. Take an example where we had a telecommunications business where you had 150 million rands worth of assets, and you had 150 million rands worth of liabilities, and you had 50 million rands worth of assets. So your whole was 100 million rand. It would have taken us, provided everything went according to plan, it would have taken us 5 years to fill that hole. Now that's just pointless. So in which case the creditors would much rather just take a haircut, take a 67% haircut, get 35 cents in the rand under business rescue, as opposed to the 15 cents in the rand that they would have got under a liquidation scenario, and sell off the assets, and that's the end of the game. So we have to be very, very pragmatic when we look at a business in the beginning. it's very important to remain pragmatic. And we don't define, it's the success of business rescue is quite a subjective thing. And I haven't read that article that you referred to, but I've heard some comments on it. Some people define success of business rescue as a return of the company to solvent going concern. Some of them define success as giving creditors a better return than in liquidation. The way we define success is whether the plan was implemented more or less according to the way it was drafted. In other words, more or less in the way that the business rescue practitioner envisaged the plan being implemented. If that takes place, then we consider it to be a successful business rescue.
Last year, practically, there was a fast food that we were both involved in, a fast food chain, outside of COVID. And I think if you just describe in greater depth, but as I recall, what you guys did is you first looked at the actual operations, and you went so far as to redesign menus and whatever. Then you gave that a shot. It increased, circumstances emerged that actually made it more difficult for the rescue. You take us through that, and then what happened?
Yes, circumstances emerged which made it a bit more difficult. So we had implemented delivery services, we'd redone the menu, we'd gone on a big social media campaign. Circumstances evolved where we were negotiating with landlords. If I remember correctly, I think there was 5 restaurants involved. One of the malls was being under reconstruction, and the foot traffic had decreased substantially. So we were left with no choice but to actually close down 2 of the restaurants. And you'll often hear rescue practitioners and so on talk about, we had 50, there were 50 branches and we closed down 30, and and the rest was saved. And unfortunately, that is a reality. Sometimes you have to close branches, sometimes you have to close divisions in order to keep them going. It's a decision that we take very heavily, because we know that we know that job losses are involved and that sort of thing. But sometimes when you've got a branch or certain divisions of a company that are simply pulling that down, pulling the rest of the group down in terms of making losses and draining financial resources out of the groups, then we actually have no choice at the end of the day but to stop the bleeding and to close those branches. And that's what we had to do in that situation. In that situation, we closed 2 of the branches, and we were left with 2 or 3 branches which were profitable at the end of the day. So we consider that to be a successful rescue in the sense that at the end of the day, you're left with a company that is a solvent going concern, but you have had no choice but to wind down the company to an extent by closing down some of the divisions or selling some of the assets. So inevitably, any business rescue does have a combination of the 2. It involves getting part of the business back to solvent going concern, and it normally involves the sale of some of the assets. It's just the ratio obviously depends, varies from case to case.
Yeah, and I'll jump in relation to that matter. From a legal perspective, it was quite interesting. Now, you've heard about the moratorium on claims. So there's a general moratorium on claims, let's say supplier claims and the like. But what you've got to be careful of, and it's important, this is why it's important to have a competent business rescue practitioner on your team, is that contracts have to be suspended by notice by the business rescue practitioner. So if you have a lease agreement and the business rescue practitioner forgets to send a notice suspending the lease, the lessor still has the right to cancel the lease in terms of in accordance with the breach provisions. And if the landlord does cancel the lease, you can be evicted despite being in business rescue because your occupation is unlawful, and an election is deemed to have been made by the business rescue practitioner to keep the lease going. So very, very important, get those notices out. If you're not going to be in the COBRA environment, you're going to be using business rescue practitioners out there. We may not know them, but make sure that they've got a reputation, they know what they're doing. And you need to put together a list of all the details of all the counterparties to all the agreements that you've entered in and that you believe ought to be suspended. Have that ready for the business rescue practitioner, so that the moment the business rescue practitioner comes on as appointed, you can send the notices out. And what happened in this matter was the lease, in fact, had been terminated prior to the suspension because the breach notice has gone down prior to it, and because of those circumstances, the lease became a massive issue. The landlord suddenly had immense bargaining power, and the dynamic changed. So important in that case was a problem, because as I mentioned earlier, business rescue is about leveling the playing fields. You don't want a disparity of bargaining power, particularly in the COVID situation. Yeah, and whilst I've got you there, you mentioned earlier when it came to what you do apropos the directors. What's the dynamic like with directors?
So, Maurice, the directors, they need to, in terms of Chapter 6, they need to continue their normal day-to-day duties and activities, except the only difference is that now they need to report to the business rescue practitioner. So the business rescue practitioner has ultimate control over the board. And that's the only way it could work. It could have worked, having a business rescue practitioner kind of, side by side with the board with sort of equal vote would not have given him the necessary power to be able to effect his duties in the way that Chapter 6 was intended. So the business rescue practitioner had to be given ultimate control over the board. Now, that can obviously open itself up to some form of abuse. Business rescue practitioners come in and they kick the CEO out of his seat, and they think they know everything about running a business and basically their way or the highway. And I think that's one of the reasons why business rescue has got such a bad reputation, because the practitioner will never know as much about the business, and he'll never have the intricate knowledge and feel for the business that the board of directors and the CEO has. So the choice of business rescue practitioner is so critical to the success of the business rescue or not. Most experts will tell you that 99% of the success or failure is determined by the choice of business rescue practitioner. So, our philosophy is to come in and to work with the board as much as we possibly can, and where we can develop a relationship of trust with the board, where they can trust us and where we can trust them. That's normally where we have the successful outcomes. We are there to get involved, to hold the board's hand, to guide them through the process of the business rescue, with us as experts in business rescue, and them in experts in their business or their line of industry. We are also there to plug any holes that might exist in terms of where they might be falling short in terms of skills. You normally find whenever we go into a situation, and that's what you were asking me earlier, we very quickly identify what the problems are that led to distress. Through talking to the board, through talking to staff, through talking to suppliers and customers and so on. It's very easy for us to quickly identify what the problems are. And those problems we can generally put into a few categories. Very often it's a company where the proprietors are very good at making their product, producing their product cost effectively, for example, but they're very bad at marketing. Sometimes we have a case where they're very good at marketing, and CEO is a great salesman, but he doesn't have the operational or the financial capability, and the rest of his business is just a mess. He just tries to catch the ball and then hopes that his operational team will be able to run with it, but that doesn't really work if he's not an operational person himself. Sometimes we find it's just very bad financial management. Sometimes we find fraud at a very senior level. So we are there to plug those holes. When there's fraud at a very senior level, at a director level, it's obviously more difficult for us to work with the board. And then it often becomes a case of either having to remove directors that are perpetrating fraud. When I talk about fraud, I'm normally talking about borrowing money with no intention to repay it, or misappropriation of assets, or that sort of thing. Then we obviously need to consider whether liquidation is not a better alternative. However, sometimes we are able to remove the directors that are perpetrating fraud, and very often the creditors will actually want us to take, and they're happy that we're there as business rescue practitioners, because now we are in control of the company. We can make sure that assets are not being misappropriated. We can make sure that we can have control of the bank and so on. So only in the case of fraudulent activities being perpetrated at the top level do we actually not work with the board. That's when we really just take control of the company, and normally results in a wind down and a business rescue. In all other situations, we are there to walk with the board, solve the problems, and get the company out of business rescue at the end of the day.
A lot of the smaller businesses have raised the issue of SARS and the fact that they haven't been that honest when it comes to the income or the expenses. How do you deal with that kind of situation? What's SARS's attitude?
Well, Maurice, that's pretty. It's a very good question, and it's a very common thing. And I'm talking openly here. It's very common for companies, to avoid tax, to walk a fine line between tax avoidance and tax evasion. As business rescue practitioners, as we all know, we are courts. We are appointees of the court. We are officials of the court, so we have duties. One of the duties is that we have to report irregularities that are found, in terms of that directors and so on have perpetrated. What do we typically do in a situation, and we have to remain very practical, and Peter always talks about this. We have to be very practical about it. At the end of the day, SARS is there to, that they are not there to close businesses down. So if we find that the directors have been evading tax, what we'll typically do is we'll work out what the extent to which the taxes have been evaded. We'll go to SARS. We'll disclose to them what the extent of the evasion has been. But at the end of the day, SARS actually, they look favorably upon that kind of activity, and they're not there to come down and the directors close them down, close the business down, and put them into put the directors into jail. They look favorably upon the fact that we've come forward to them, told them what the problem is. And then what business rescue allows us to do, and what we do in every business rescue, almost every business rescue, is that the creditors take a haircut. So SARS is one of those creditors. So we work out, we'll put forward a haircut that SARS can take, or a compromise by which they will reduce the debt that is owed to them, and the company will end up paying a reduced debt back to SARS. In other words, us getting involved and going to SARS and telling them what's been going on does normally not result in the company having to pay more tax at the end of the day. At the end of the day, it just squares things up with SARS. We've acted in our duties as business rescue practitioners. We've acted correctly, and the business doesn't pay more tax at the end of the day. Sometimes we end up even paying less.
Just for the audience, COBRA had an insurance webinar yesterday, and we discussed the topic of business interruption insurance in these circumstances. And the point was made that when it comes to juking the books, now when it comes to you claiming from an insurance company for business interruption, now your income, your profitability is down, and you're stuck with that. So in this situation, it'll come back and haunt many businesses, particularly when it comes to the claims. You mentioned, Ian, that part of what business rescue is about is plugging the holes in skills. I think importantly, if you can just take us through the skills of BRPs, because I know you're a chartered accountant, and I think what's unbelievable is, particularly for the smaller businesses, the moment that you come in, they have somebody as skilled as you and Peter, and they have attorneys and the like. Can you just take us through the qualifications of practitioners?
Absolutely. So, Maurice, the CIPC requires business rescue practitioners to be either from an accounting field, qualified accountants, or not necessarily chartered accountants, qualified accountants, attorneys, or from a business management profession. Okay. Now, the reality is that the skills involved in being able to turn around a company, in other words, to do turnaround and business rescue properly, are so much more than just being an accountant or an attorney. We always believe that the skill set is so wide that it's almost very difficult for one person to have all the skills to be able to do it properly. In fact, we believe no one person actually does have all the skills. So what we have at our core, as engaged and as COBRA, is a team of senior skills that comprise all the skills that we believe are necessary. And those skills, we list them as about 8 skills. We list them as leadership, entrepreneurship, strategic skills, financial skills, legal skills, operational skills, deal making skills, and capital raising skills. All those skills are necessary in order to be able to do this job properly. So we, from a very early stage, we work out what the problems are, we work out what skills need to be applied, we get our senior team in, the people with the required skills in, to be able to assist and to fix the business, to work out a prognosis for the business, to work out whether it's feasible to fix the business, and then to apply those skills to fixing it. Now, obviously, these are core business skills that I'm talking about. What we also need is the specific industry skills. So when we get involved in something like logistics, for example, we have industry experts within our network. So obviously, between a substantial number of core individuals, we've got a fairly extensive network, a trusted network, and trust is very important. It's a very important word to be using here, because we need to be able to bring in experts in their specific industries that do not have a vested interest in telling us something that will just put money in their pocket at the end of the day. So we have a trusted network of expert skills that we can draw on. We can bring in a logistics example. We can bring in a logistics specialist that has worked with us for a very long time, who we know very well, who we trust, and he will give us independent, expert advice that is purely geared towards solving that company's problem that we are busy with. And that is critical. And because of our fairly extensive network and number of senior individuals at our core, we have those networks, those trusted networks of skilled individuals that span almost every industry across the country.
Yeah, I think the point must be made is just look behind me. These are not all the partners. We've had 4 partners on board. We've had Microsoft that's not listed here, and they've all agreed to act on a pro bono basis, subject to the means test that you'll find on the COBRA website. So you've got these skills at your disposal within the COBRA ecosystem, which I think is an important point to be made, because if your business is in distress, I think the obvious choice would be COBRA, simply because you have skills like IQ Business. Do your research on IQ Business. IQ Business has been around for 22 years. I've known them for 22 years. And they're there not only to fix businesses, but to improve business efficacy. Now, in this context, you have that available to you. So it's in my mind, a no-brainer. Peter, we mentioned, and I'll get to Dean now. Just dealing. In fact, let's deal with Dean. Dean, we dealt with the topic of fraud. I see you on mute. You've been dealing with these funds quite a bit, and I know that there's certain. If you can just take us through the funds to begin with, or particular funds that would apply to, let's say, retail. But there are requirements such as you're going to be up to date with your UIF. Now, yes. We talk about people not being that savory when it comes to their books for the fiscus, for SARS. It appears that that now extends to these funds. Can you just take us through that?
Sure. So just in terms of the funds and the relief funds, you'll find a full list of them on the cobra.org website. If you go down to the bottom of that website, you'll see there's a help portal and a knowledge base. So there's some really nice snapshots of the funds and relief measures that are available. But in terms of the ones we've been asked quite a lot about, and it's this the TERS fund, which is the Temporary Employee Relief Benefit. And there are a couple of, I'd say, first points that you have to be compliant with, obviously, before you can even make use of this. And one of them is that you are paying your UIF. Okay, that is a must before you can even apply for this TERS fund. And again, as you say, part of that application comes down to you've got to the size of your workforce, how many employees you do have, and you have to create an application form on behalf of the various employees in your company. And those can go from anyone who doesn't or can't work anymore, or someone who is able to partially work anymore. So in terms of, to get back to your question on the, whether or not their SARS records have to be in place and the actual business governance needs to, absolutely. I think before you can even start trying to put on these funds, a lot of it is good corporate governance. And that's just on the TERS aspect. And you mentioned the retail. There's been quite a lot of development in the retail industry, especially for tenants recently. And the main one we're looking at the moment is this property industry group. It's a collective that was formed by some of the biggest bodies in retail and real estate. So it's the SA REIT Association, SA Property Owners Association, which is known as SAPOA, and the South African Council of Shopping Centres. And again, what this is in essence is a package of relief for retail tenants, SMME retail tenants, where they have certain qualifications. And at the first glance, before you even get into the percentages, the one is that you have to undertake not to retrench employees during the relief period. And the other one is you actually have to be up to date with your rental to the end of Feb, the 29th of Feb, this year's being a leap year. If those are ticked, then you can start looking at other types of relief. And they offer a discount on rental per month, and they offer an interest-free deferred payment between 6 and 9 months, depending on what class of the SME you are. And it's quite nice because it's quite a wide base. They've used the same definition as the DTI, and that is a SMME that is an annual turnover of below 80 million a year. And it distinguishes between the first and second class, a level 1 and level 2. Level 1 being the highly impacted SMMEs, and these are the SMMEs that would be selling time and services, and that's where a lot of our questions are coming from, the sectors. So it would be restaurants, hairdressers, travel agents, takeaways. And for them, their relief packages in April, they could have up to 35 to 100% discount on their rental, with further discounts in terms of this interest-free deferment over 9 to 6 months from the 1st of July. And in May, they have about a 50% discount on rental, also with the deferment, an option of a deferment of 9 to 6 months. So those are the main points out of that. The nice thing is, and I think it goes down to what Ian was saying earlier, is in order to engage your landlord on these, and it goes with all the other funds, the government or not, you actually have to have a very good snapshot of your company. You have to know what your balance sheet is. You have to know what your books are, how strong you are in terms of your cash position, and your corporate governance probably has to be in line as well.
Thanks, Dean. Dean, I was asked the question, and I didn't know the answer, and I'm not sure if you know or any of the panelists, but is it possible, let's say in the case of UIF, to regularize the situation, bring your UIF up to date, pay the penalties, and then apply?
Sure.
I don't know offhand. I could probably, it's Pierre, I don't think Pierre is on today. I don't know. Yeah, any...
Does anybody know? I think we need to look into this today, and let's put something up on the website, because I think that's a very, very important point.
Sure.
So for the audience, there will be something on the COBRA website as to whether you can regularize.
Yeah.
I also want to mention that in relation to the property relief, the associations, I think it was yesterday or the day before, somebody posted on the webinar Q&A that they actually being threatened with eviction if they do not agree to the terms. And I just think it's important for the audience to realize that a counterparty to a contract cannot unilaterally vary that contract. So that's why they're relying on duress, being commercial duress being the eviction. But our courts are closed at the moment. They're only entertaining urgent relief. And as I've mentioned previously, if a landlord wants to start talking about evictions to try and get you to sign something, you speak to COBRA, they deal with the landlord, if need be, business rescue, and then you can sit down and negotiate. So just bear in mind that there's no obligation on you to agree, and the duress is not what it was three months ago because of the fact that the courts are in effect closed. We are trying to do something about that. Representations by us went to the minister, in fact, this morning. I also want to mention, just flowing from a comment that was made, that when it comes to SARS and UIF, the duty to report only arises the moment the business rescue practitioner is appointed. So these duties to report to SARS any nefarious conduct by the directors would only arise at that point. The COBRA team are not concerned. They don't want the business rescues. They don't want it to go into business rescue. So for that period, there's no reporting obligation, save in the event of a director. A director would have a reporting obligation in terms of Section 34 of the Corrupt Activities Act, but certainly not the business rescue practitioner pre a rescue. Peter, can we deal with the scenario that we've dealt with repeatedly, there also being questions where we have shareholders who desperately want to assist their staff, and they intend putting money in pre-rescue on loan account to settle the staff. Was that a wise idea?
Maurice, no. A shareholder putting money into a company pre-rescue, if the company then goes into rescue, remember where I said right at the beginning that that amount is then frozen and will only be repaid in terms of the business rescue plan. And were the company to then ultimately go into liquidation, the creditors would receive a liquidation dividend. The best thing to do is to wait until business rescue is put in place, because then any funding that goes into the company is preferred. So a shareholder putting money in after business rescue would, without security, firstly, would be preferred and has to be repaid out of the proceeds of the company continuing to trade during the period of business rescue before any other creditors can be paid. So the practitioner is obligated to settle all what we call PCF, post-commencement finance, before he can start paying out creditors. So it's far more secure, and indeed this is a provision in the Act which enables the practitioner to negotiate principally with the banks, because why would the banks put more money in if they already owed money and what they owed has been frozen and it's probably secured and that's been frozen as well. But the banks can be enticed to continue providing normally an overdraft, working capital facilities to the company, because they know that that amount that's been advanced post-rescue date has to be repaid. So it is sensible for a shareholder. The other important thing with a shareholder is there's nothing to stop a shareholder or a director asking for security. So the business rescue practitioner has total control over the assets of the company, and if those are currently unencumbered and there is some free value in them, the business rescue practitioner can offer those. Obviously, he's going to be quite selective because you're using the assets as best you can to raise capital, but he can offer those assets up to the shareholder and or director who's providing the loan as security for their debt. And that's a very good thing to do, because if the company then goes into liquidation and the rescue is unsuccessful, that preference still stands. However, the one thing to just remind ourselves, if there's a mortgage and there's some headroom in the mortgage, in the value of the property, and you offer the second mortgage to somebody, the bank would still have first cut at that, or who's ever taken the mortgage, will that first have cut of the pie in whatever is recovered for that particular asset. But any other assets like movable assets, stock, debtors, etc., the secured creditor post-rescue is what we call super preferent over all other creditors in a liquidation. So it's a very good protection to do it after rescue rather than before.
Yeah, we've dealt with rescues where we've put the business into rescue simply for that, to take advantage of the super preference. So it's important that I think the take home here is, if you're going to put money in, speak to COBRA. COBRA can assist in ensuring that you get super preference in relation to those funds.
We lost you, Maurice.
While Maurice is not with us, I just see one of the questions here. Can a business rescue practitioner be the same firm that prepares the annual financial statements, or would that not be considered independent? The practitioner has to be independent. So in that case, no. The auditor, the preparer of financial statements, the bookkeeper who might be a consultant to the business, cannot then take on the role of business rescue practitioner. That independent is important. The Act does allow the practitioner to do some pre-rescue investigations, and that doesn't impinge upon his independence. And I've had an example where I've been involved in a company for a while, giving them ad hoc advice. And the advantage to the company is that in rescue is that I know the company well. I know the operations extremely well. And in that case, one can overcome the independence problem by merely asking the creditors if they're happy. Because remember, they're the ones that are voting on the plan. And it's a matter of tabling that to the creditors fairly urgently and saying, this is the situation, this is the involvement I've had. Are you all comfortable that I'm going to do this rescue and remain independent? And if you get the creditors to vote on that and give you that approval, you can still do it. But under normal conditions, somebody preparing the financial statements for a company wouldn't be classed as independent.
Yes, Peter, sorry, Marisa, we lost you earlier. Peter and I just started talking about this question that was asked about the person preparing the financial statements, then being appointed the practitioner. It ties in quite closely with the question of, if we are appointed as turnaround practitioners in an informal business rescue, in other words, an informal turnaround, in other words, pre-business rescue. And we've had this situation where we've taken on an informal rescue. It's run for 4 months, and then the necessity came about to put it into business rescue. One of the creditors wanted us to take control, or the creditors actually wanted us to take control. We needed to take control of the board. In that case, we could have potentially been challenged that we weren't independent because we had been involved in an informal turnaround capacity, and the company had paid us to be informal turnaround consultants prior to business rescue. But we got the permission of the creditors to then become the business rescue practitioner, and everything was fine, and we weren't challenged on it. But it is important to notice that when we are confronted with a situation like this, it's important just to note that it might be subject to challenge at some stage by an affected person. But belt and braces approach, as Peter likes to say, is to get the approval of the creditors for us to take the business rescue appointment after that.
Thanks, Ian. Whilst I've got you, you often spoken on the show and said that part of what's really, really important as to what you do in a plan is take fixed costs and do everything in your power to make them variable with reference to changing circumstances, so they're pegged to changing circumstances. That's their variable nature. Now, in relation to labor, there are also a lot of questions. That's an obvious variable cost. Well, fixed cost that one can make variable. How does one go about doing that? How have you done that?
Well, whether it's under business rescue or not, the Labor Relations Act is exactly the same. Employees are protected to the same extent under business rescue as they are in the normal course of business. So it comes down to negotiating an arrangement with employees, and we can do that pre-business rescue. So most employees we've dealt with so far under COBRA have been very reasonable. They realize the extent of the situation, the extent of the crisis. They realize that they would rather get half of their salary or even a third of their normal salary rather than getting nothing. So the process is to engage with them, and the the process of engagement as required by the Labour Relations Act is substantially less. So you don't need to go through the whole formal engagement process prior to the actual retrenchment, as it may be. But what you would put forward to the employees during that process is the extent to which we propose their salaries get cut during the crisis, and so on. In our practical experience, as I said, they are more than likely to accept the proposal, maybe with a little bit of negotiation and so on. If they are not willing to accept the proposal, then we have no choice but to retrench them and to pay them out according to the notice that needs to be paid and the standard retrenchment pay. But as I said, employees have been very understanding of the situation. At the end of the day, they would much rather play the game, potentially have a job at the end of the day, but take quite a substantial cut in their current salary.
Thanks. Peter, there's a question in relation to different forms of security in a business rescue. I think it ties in with the question of sureties. A lot of audience members will have signed sureties. What's the impact of a surety and business rescue? The question is, what happens in the case of liquid security as collateral for a property facility, i.e. being personal residence or business? So that would be in the form of a suretyship as collateral. And yeah, so what would the position there be, Peter?
Maurice, the personal security that's been offered up on behalf of a company isn't protected in terms of the business rescue. The important thing is to understand the terms and conditions of the suretyship itself. If the suretyship allows the provider of the funding, normally the bank, this is classically a bank prepared to give an overdraft facility to a company, doesn't like the assets or takes the assets, but also asks for personal guarantees by way of a suretyship from the shareholders. So what one's got to do is understand the terms of that suretyship, because if the bank has a term in there that allows them to take individual action independent of each of the parties, i.e. the shareholder as in person and then the company, then the bank can continue to pursue their security. What we do that's a very good question, because it's one that we always ask fairly early on in a rescue, especially mainly in the SMME area, is, has personal suretyship been signed, not only to the bank, but to anybody? Very often people forget that they've signed a personal surety. They bought a photocopy on a hire purchase type agreement and signed surety at the same time. It's sort of in the small print of the agreement. So be very careful of these. What we would do normally with the bank is go and negotiate with them and make sure that they're not going to be worse off in the rescue. We've just concluded one of these recently where we negotiated with the security holder that we would pay them a larger dividend out of the company, and that the shareholders would pay them the balance over a period of time. And they were happy with that. So it is a negotiation. Bear in mind, broadly, the banks would prefer not to put somebody out of their personal residence because they've signed personal suretyship in a company. So unless there's been fraud or a complete lack of trust between the bank and the individual, normally the banks will be open to negotiation on some sort of structured deal to make sure that the parties, the individual survives and isn't kicked out of their residence.
Yeah, thanks. When it comes to the business rescue plan then, shareholders with massive loan accounts. So let's say a shareholder has a loan account to the tune of R1 million, and that's his claim against the company, and the creditors only amount to, the trade creditors only amount to 10,000 rands. Now he signed surety, he or she signed surety, and what he or she would like to do is take advantage of the size of the loan account to vote a plan in that will work in favor of the shareholder apropos the surety. Would that work if you have a million rand loan account and your trade creditors are only 10,000 rands? Could you just come up with a plan and vote it?
Maurice, no. I mean, it's an interesting question because there are extreme amounts. What I'd suggest to the shareholders, find 10,000 rand and pay the creditors and become the only creditor in the plan. And the reason for that, and Ian touched on this, in the vote, you need to get a vote, to get a business rescue plan adopted, i.e. positive vote, you need 75% of the creditors who voted. Important point, those that voted. Those that didn't turn up to the meeting to vote cannot claim, and it's in the Act, cannot claim afterwards because they didn't vote. They're not bound by the plan. Everybody's bound by the plan. Once the creditors who did vote, and that's in person or by proxy, have voted, 75% have got to say yes. And of that 75, of the total votes, of these 100 Rand voting, and 75 have said yes, the plan should pass. But of the 100, or rather of the 75, 50% has got to be independent. And in that example, 50% of the total vote. So that would be 2/3 have got to be independent. So this would be a silly scenario that a 10,000 Rand creditor would control the plan because the shareholders are not independent. So what the shareholder, and that's assuming that the creditor votes against the plan, of course. If the creditor is minded, and we do lobbying beforehand to find out to make sure that the plan gets voted. You don't want to present a plan that gets voted down, because that's a lot of effort and a lot of pain. And there's a process that you've then got to go through. But you've done lobbying beforehand, and if you know that the creditors are going to vote for the plan, then you have this rather intriguing situation. You've got to tell the shareholder not to exercise his vote, because you're going to get a vote from the 10,000, and your 10,000 votes yes, your plan's adopted. So and it's a numbers game. You've got to work out what percentage of a shareholder's vote can be voted on, and ask them to only vote for a portion of their loan.
Yeah, we almost done. I'll get to questions. I just want to mention this whilst we're on the plan, that a plan can be very, very simple, and the business rescue can be very, very quick. We were involved in a business rescue that involved a Camps Bay restaurant. I mention this each time because it was quite a remarkable business rescue. It was handled by one of our partners, Agility, the business rescue practitioners, and they got appointed. They met with the landlord. They reduced the monthly rental by being transparent, showing the book, saying, look, this is what's happening under the hood. Landlord saw that the rental was not sustainable, reduced the rental, pulled out of business rescue, and it was a successful rescue, and the company continued to trade for the balance of the lease. Not very profitably, but above water. There's a question here, does PCF funding from a shareholder using company assets trump landlord's hypothec? Peter?
Maurice, yeah, to the degree that a secured creditor is frozen, you don't affect their security. So if you've given PCF security over something that's already been used as security, they would almost be like my example earlier of a second mortgage. So the landlord's hypothec would still exist. But remember, the landlord's hypothec is normally limited anyway to a period of rental. So it's important to work out exactly how much of the whatever the asset is, how much of it has been used up by the landlord, and then allow the balance to be used as security for the shareholder putting post-rescue financing.
Yeah, I think let me address it from a more technical legal point of view. So when a landlord's hypothec needs to be perfected, a perfection is done by way of a court order. So it's either a rent interdict summons or an actual application where you attach and you perfect the hypothec pending the dispute in relation to the rental. So the hypothec cannot be relied upon until it's been perfected. And if it hasn't been perfected pre-rescue, it cannot be perfected post-rescue because of the moratorium. So in that case, if there hasn't been a perfection and there's PCF, the PCF would certainly trump it because there hasn't been a perfection. I'm also pretty firmly of the view, and I'd need to double check, that even if it was perfected, PCF would trump a perfected hypothec. But again, Dean, if you just make a note of that, let's look at that. And
Maurice, but it's an important point because that covers all security. You have to perfect your security in order for it to be exercisable, if I can use that word.
Got a question here that I'm going to think about as I read it. What happens in the case where the facility is in the name of a trust, i.e. a family trust with most of the assets in the name of some or some of the trustees being minors? How does the BR impact or affect the trust facility? So I'll answer that. The trust presumably would be the shareholder and would be immune to any claims unless the trust signed a surety document and gave some form of surety. I presume that it's not a business trust, that it's an ownership trust for the benefit of the family. As I said, if it didn't sign surety, there's no problem. And if the trust is a shareholder in a business, it remains immune. Even if it wasn't a trust, shareholders aren't liable merely by virtue of the fact that they're shareholders. They can be held liable, but that's only in relation to misconduct on their part. So it depends what you mean by a trust facility, but yeah, that's basically the risk only relates to some form of security that would have been put up. I think that concludes today. Thanks to the panelists. Thanks to the audience. I think I've dealt with all the questions. This was a great session. Please look out for our other webinars, quite a few next week. They targeted webinars dealing with specific issues such as evictions, the question of prescription on claims, and the others. So look out for those. Sign up for our newsletter. And if you have further questions that you think of, please set up private Zoom sessions with us. We're more than happy to address specific questions with you and your team. Great. Thanks a lot. Cheers, guys.
Thanks, bye.